Good morning to you. So, this is an introductory class for the Constitution. The Constitution has been made a subject of study for section officers examination at par with normally civil service exam. Now, you might have seen Constitution right from 10th standard onwards, 10th, 11th, and some of you may be even political science graduates. But from constitution point of view, you should know what exactly is the unique features of Indian constitution, which no other constitution has. 10th standard and other newer lower classes, you might have studied so many things about the constitution, bulkiest constitution, parliamentary form of government, etc., etc. But here you should know what are the unique features which no other constitution in the world has. First thing is Article 22, preventive detention. India has the dubious distinction of being the only country in the world which has preventive detention under Article 22, even during normal times. No doubt, UK also has, but only during war. In US, it is unknown. Under preventive detention, the person can be detained in custody. What is then when you talk of preventive detention, what do you mean by other detention? That is called punitive detention. Punitive detention, remember, you know what is the crime you have committed and what is the penalty under Indian Penal Code, what is the penalty, what is the definition of crime, and there is a CRPC under which the procedure for awarding the penalty is followed, and there is an evidence act which provides the qualification of the evidence. All these things are provided. Trial happens before the magistrate, and you have the opportunity to defend. You can engage a lawyer, and finally the penalty is awarded, and you are undergoing imprisonment. That is called punitive detention, remember. On the other hand, under preventive detention, you do not know what is the crime you have committed and how much period you will be detained. You are simply taken to police custody and you will be kept behind the bars. The other rights are not available under Article 22. What are the rights available under normal law of crimes are not available to the preventive detention. This is only in India, remember. Second is ordinance making powers. Article 123, 1, 2, 3. In governor, it is 213, remember. Under Article 123 of the Constitution, President can promulgate an ordinance. What is the speciality in this? Very simple. Normally, ordinance is a law. Law, even though it is pending approval by the Parliament, it has the effect of law. Under separation of powers, executive is to implement the law, and Parliament is to enact the law, and judiciary to interpret the law. There is no strict separation of powers. President is the executive head, and he promulgates an ordinance under Article 20. That is usurpation of powers in the normal terms. But there are certain exigencies where the President of India promulgates an ordinance, proclaims an ordinance which has a force of law. Remember, no other country has this provision. No, there is no other country which has this provision. Secondly, another thing is anti-defection law. Anti-defection, very notorious. Nowadays it has become notorious. 1985 onwards it is there. Contribution of Rajiv Gandhi, 10th schedule. And there is no, you won't believe your own legislators. The people elect them. We, the people of India, solemnly give this constitution to them on 26th November 1949 and adopt. This is the date of adoption, and we are having 26th January 1950 as an implementation. This constitution, which is given by the people for the people, they the people do not believe their own legislators. They only elected them. But the constitution has been amended, and we have introduced what is known as anti-defection law, under which the member who violates the policy given, principles given in anti-defection law can be disqualified. No other country. Remember, no other country. And the fourth, remember, Article 136, SLP, Special Leave Petition. Normally, when you go to the apex court, highest court of the land, you should exhaust all your outlets in the lower formation. Suppose you are all working in the government. You say there is a disciplinary proceeding has been instituted, or you have been awarded a penalty. What are you going to do? You go to the secretary. What secretary will say? No, I won't entertain you. First exhaust your, who is your appellate authority? Go to him. Then you go to the revision authority. Then you go to the reviewing authority. I am not concerned with that. If I am the concerned authority, then you come. The truth root representation. But here is the case where the Supreme Court entertains under 136. No other Supreme Court. The Supreme Court, judiciary is the most powerful in USA. Even USA, there is no such procedure for Article 136, that is special leave petition, where a person can directly go in respect of interlocutory nature. The case is pending in the lowest court, second magistrate, he can go directly. And the case has not been finalized by the, not only judicial orders, even tribunal orders. Any order can be appealed against. You can go directly. There is no need for you to exhaust the what is called normal appellate channel. This is available only in Indian Constitution. Then Article 143, remember, President of India as executive can seek the advice of the Supreme Court on any matter which is of public importance. Article 143 of the Constitution, normally audit and the Supreme Court and any court for that matter will not give any opinion on hypothetical basis. No, it is not at all. And this is the unique power which no other country has. No other constitution has the provision for Article 143. It is the current to the Supreme Court. They give advice. Remember, such an advice is not binding on the president. Suppose you ask some advice about me, can I opt for MACP or regular promotion? My advice to you, it is not bound for you to accept it. It is for you. So, because you asked only advice. Similarly, the president is not expected to obey or follow the advice given by the Supreme Court. But whereas the orders of the Supreme Court, the judgment of the Supreme Court is binding on all the courts. This is also again unique for the Indian Constitution. No other constitution. Another is, remember, fundamental duties. Fundamental duties is a unique feature. No other constitution. Of course, you may point out immediately that Japan has. In Japan, right to work is a fundamental right. Right? Whereas in India, it is not a fundamental. It is only what is only 100 days. The employment is assured. And fundamental duties is somewhat contradictory to the reality. Who gives the constitution? We, the ultimate power is derived from the people of India. We, the people of India, give this constitution unto ourselves. Whereas the people, you think that people are irresponsible? Do you think 135 crore of people are there? Do you think even, you go to Chandri Chowk, you go to railway station, how many thousands of people are there? If even one person is dishonest, what would have happened? No, it is very, 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 very rare. So we think that the people are not honest. We think that the people are indulging in dereliction for duty. So you have here, because remember, none of these are my opinion. It is all the opinion given by the constitutional experts. Why these fundamental rights have been given? Of course, then come Article 370. It is unique. There is no special status. Fortunately, Modi government has abrogated the Article 370. So these are all the very unique features of Indian Constitution.